Sometimes ownership of property needs to be shared. Couples and friends living together, married, civil partnerships or unmarried, parents helping their child to buy their first home, or situations where there is a shared ownership scheme. In the UK, there are two ways of registering your legal ownership shares in a property: beneficial joint tenants or tenants in common. Holding the property as beneficial joint tenants means the property is owned jointly without any specific share attributed to each owner. Under this arrangement, if one owner dies, the other automatically inherits the property. You may not want this to happen if you have bought the property with a friend or relative, or if you have a share in a property with a housing association. Holding the property as tenants in common means that the property is owned jointly in specific shares. Under this arrangement, if one owner dies, the other does not automatically inherit the property. Instead, it goes into the deceased owner's estate and can be transferred or sold and inherited by a beneficiary. If this option is selected, the owners can agree in advance what happens if one owner wants to sell their share in the future, how any expenses related to the property are paid, and who inherits their share if they die. Buying a home is usually the biggest investment in our lives, both financially and emotionally. We need to be sure we make the right co-ownership decision to safeguard ourselves and our loved ones should unhappy things happen. Like death, disputes over repairs, disputes over who made a contribution to the purchase price, divorce or separation, or if our co-owner just wants to sell and we don't. Our lawyers can help you make the right legal ownership choice, and they can advise you on how to agree all your co-ownership arrangements up front so you can rest assured and minimise future disputes. They can help you change the way you co-own property. Don't leave the biggest investment of your life to chance.